Good afternoon, ladies and gentlemen. Welcome to part 2. In this portion of the segment, we're going to be talking about corruption. And we're building on Rebecca Dobson Phillips, Elizabeth Dávid-Barrett, and Robert Barrington's article defining corruption in context. And in the first portion of this video, we talked about entrusted power, abuse, private gain, and harm to public interest. And when we're looking at this, there is a pyramid that they provide that's right here. So you can see this pyramid. And they argue that the pyramid should be read from the bottom up as a series of tests that can be applied sequentially to refine the conceptualization and identify cases of corruption. So from the bottom toward the top. And it says, they argue that if it does not pass all 4 tests, then we can conclude that a case is not corruption. So here during this segment, we are going to see if the lack of investigation into cybercrime constitutes corruption, right? But I first want to elaborate on entrusted power because there was a very short definition, but entrusted power, there's a relationship between parties, and to reiterate, the public entrust police to carry out their duties responsibly, or to investigate certain kinds, or to investigate criminality in general, or to not harm us, right? And I think there are many kinds of relationships in the world where we entrust people to do as their job description tells them to do, or to abide by a code of ethics. Think about, for example, lawyer-client relationships. And if you're a client and you have instructed a solicitor, you entrust that solicitor to give you the best defense and to work in your interest and not in the interest of someone else. And abuse, I guess, would be considered where they are working in the interest of someone else and not in your interest. And when we look at cases of cybercrime, abuse can be considered where, to reiterate, law enforcement is not investigating cybercrime or cyber intimidation, cyber harassment. And the scholars argue that abuse is only relevant within the context of duties and obligations created by the entrusting relationship. So do police have the duty to investigate cyber criminality? Do they have the duty to investigate cybercrime, harassment, cyberbullying? And I would argue yes, according to legislation. But what happens, to reiterate, when they don't investigate is that an abuse. And according to the pyramid structure, that would constitute abuse. So here we have police within an entrusted role. So we're checking that off. So that they meet the definition of being in an entrusted role. We have abuse. Was there an abuse? Yes, because there was inaction to look into this cyber criminality. Well, what about private gain? Private gain is considered third because private gains are only corrupt if they flow from the abusive activities of those in positions of entrusted power. So, what did you gain something because you did not investigate this crime against this person? Did you gain something? Was there funding put into your organization? Was there funding put into your services? Did you gain something for not investigating the action of cybercrime, cybercriminality, cyberbullying, or for not raising it? We can look at the Northern Ireland Human Rights Commission, right, where I essentially raised this to them. Was there a gain there when they did not look into it and did not investigate it, or did not take it to the commissioners? Was there a gain that was in place? Now remember, private gain need not be financial. It can be non-financial. Financial private gain can be recognition of some sort, right? Well, what about public interest? Public interest is considered fourth because the first three tests, entrusted power, abuse, and private gain, can still leave researchers and practitioners with ambiguous cases that the public interest test can assist with resolving. And looking at, for example, let's go to, let's say, for instance, abuse, right? Reliance on laws and law enforcement to identify corruption places great confidence in the process of lawmaking. So we do rely on law enforcement to look into these particular situations and these incidents. It assumes that laws are comprehensive and that lawmaking is immune to corruption or corrupt manipulation, despite the many risks of improper influence over policy formation, often characterized as state capture or legal corruption. But there's something else that I found to be quite interesting, is that corruption occurs. Let's get into this. Corruption occurs when an official charged with a public responsibility operates in his or her own aims, interest, so his or her own interest, in a way that undermines the program's aims, whatever they may be. So could a law enforcement officer refuse to investigate a crime because they're operating not through the program's aims? So, for example, if they're tasked with investigating cybercrime, cyber hacking, and harassment, could it very well be that they're not investigating because they're doing so for personal reasons? And does that personal reason harm the public? Is the question. What do you think? Does that personal reason harm the public? This brings me to so-called noble causes of corruption. And an example would be where police officers falsify evidence or break rules and other ways to secure a conviction of a suspect they believe to be guilty of a crime. Now, what does this ring to mind? This rings to mind entrapment, right? So you're falsifying evidence and you are breaking rules, another way to secure a conviction against a person. This rings to mind entrapment. And what is that? Police conduct which brings about state-created crime is unacceptable. So before I get into that, if you create a situation where you're trying to incarcerate a person or to bring criminal charges against someone when you know that that person is not seeking to engage in criminality, that is considered entrapment. Let's read that again, because I think it's important for us to understand this and to look at this through the lens of why states and their proxies engage in cyber hacking. They're doing this because sometimes they're just trying to collect information about you and trying to discredit you or trying to figure out a way to bring charges against you. Police officers may falsify evidence or break rules in other ways to secure a conviction of a suspect they believe to be guilty of a crime. And so it's important to understand that police conduct which brings about state-created crime, which that is unacceptable and improper, and to prosecute such circumstances would be an affront to public conscience. So the courts say that whenever there is an entrapment defense, that proceedings should be stayed because the state is creating crime. State-created crime is unacceptable and it's improper to prosecute a person in those circumstances. And it's an affront to the public's conscience. Deciding what is state-created crime, in deciding what we consider to be state-created crime, we don't look at the predisposition of a person. So that's not the criterion, okay? But entrapment techniques can be used, as we know, to induce a person to commit a crime that they would not want to commit. And I think this is quite interesting because the law says that police officers can use entrapment techniques if it is consistent with ordinary temptations. But let's say, for instance, a person does not want to be tempted. A person doesn't want to, unfortunately, engage in criminality. Is that illegal? And the law says yes. Because providing an opportunity to commit a crime is intrusive. So when law enforcement provides the opportunity to commit a crime, that is an intrusive act. So according to the law, the more consistent their overtures, the more readily a court may be ready to conclude that they overstepped the boundary. Let's think about this for a moment. Law enforcement and their proxies plant 20 pounds on an abandoned street consistently in the path of a person, an asylum seeker, to prove that that person is a criminal. And they're doing that so they understand, because again, they have surveillance apparatuses. They understand exactly where the person is going to be walking. And so they consistently place money, 20 pounds, in that person's path because they want to prove that that person is engaged in criminality, or not only to prove that that person is engaged in criminality, but to withdraw their asylum support. Well, the law says that this constitutes entrapment because, for example, if you're planting funds in a person's path, well, those funds don't belong to a person. You just you abandoned it there. Okay? And so at the start, this is state-created crime because you know that what you're doing is wrong. And so you're putting that on the street because you understand that maybe the person is destitute, they're at the end of their allowance, they're hungry, and you're putting it there because you know that there is a temptation that person is going to use that money to buy something to eat. That is illegal according to the law. Planting is, so to be sure, planting money is more than merely responding to an existing offer or observing an independently occurring offense. You have planted it there on an abandoned street because you know that person is going to be walking there in that path. And your purpose is to say, well, this person picked up 20 pounds from the street. They must be a thief, or they must be engaged in criminality. But in reality, you're planting that money there when that person doesn't have anything to eat. You're planting that money there when that person allowance is running out. You're planting that money there in a moment of desperation when you know that person is hungry. And according to the law, when there is a consistent pattern of doing something like that, that's illegal and that's corrupt. So noble corruption, you can say, well, this is a noble cause. We're trying to catch a criminal. We're trying to catch a person who is picking 20 pounds off the street. But again, the law looks at it as abandoned, right? Because you left it there. And it's not as if like you left, for example, let's say, for instance, an iPhone there on the floor, like, or on the ground. We know that if there's an iPhone on the ground, there is a high likelihood that belongs to somebody. Their information is in that iPhone. A reasonable and prudent person, knowing the circumstances, would not pick up such a device because they know that it contains person's information in it. And if they do pick it up, they'll likely try and find out who the owner is. The authors and scholars argue that noble cause corruption has morphed into complete disrespect for the law and opened the door to all kinds of corruption. So this would be considered a noble cause corruption, right? Because, to reiterate, law enforcement through their proxies are attempting to entrap a person to put a label onto them. Now we're back to critical victimology, right? To put a label on a person as, okay, you're a criminal. And so we're going to place this on the street where we know that you're going to be walking, and we understand that you're at the end of your asylum support. You've already spent all of your funds. You're likely hungry. And so if we plant it there, we understand that you're likely to pick it up. But the law says that if a person, if they pick it up and they, so let's say, for instance, there's 20 pounds on the ground, on the street, it's abandoned, nobody's around, and someone picks it up, they're hungry, and they buy food with it. Well, that's not illegal because, again, for one, it's abandoned. It's difficult to determine who that 20 pounds belongs to. Let's say, for instance, there's an abandoned 20 pound on the street, and there are 3 people around that you go to, and you ask a person, does this belong to you? That person is likely going to say yes. And then if you go to the next person and say, well, does this belong to you? That person is likely going to say yes. If you go to the next person, that person is likely going to say yes. It's really difficult to determine who that 20 pounds belongs to. Whereas if there is an iPhone dropped on the ground and you ask, does this belong to you? That person could say yes. And then you say, well, what is the photo that's on the screen? That's your screensaver. And if the person says, well, it's this, and they have that wrong, then that's a likelihood that that person doesn't own that phone, because a person is opening their phone each and every day. So secondly, you ask the second person and they tell you exactly what the photo is, and they tell you the code and everything to get into the phone. Well, we know that that's the person's phone. So this noble cause of corruption is none other than entrapment that police engage in, especially cyber hackers and cyber criminals. In another video, we'll go into more detail about this, because I really want to have a longer discussion about this. But I want to go back to public interest. And the scholars argue that if harm to the public interest can be identified, then the activities concerned have a corrupting effect. But if there is no harm to the public interest, then they fall outside of the definition of corruption. Well, is this planting 20 pounds on a street where there is an impoverished community, a poor community living, is that harm to the public interest? And I believe it is so, because they would not plant 20 pounds on the street, for example. They wouldn't plant it at Queen's University, where there is a lot of traffic of students, Irish students walking around the university. They wouldn't plant it there, because they know that that would debunk their argument that those students would not pick that up as well. Like, for example, I challenged them to do that, to plant a 20-pound bill at Queen's University during high traffic and determine whether or not a person will pick that up. A person at that university or at Ulster University. And they didn't do it there because this would go against their argument that certain communities only engage in criminality. So does that harm the public interest? Yes, because public interest can include direct harms to the intended beneficiaries of the entrusted power. We're entrusting the state to, act with ethics and morals, as well as indirect harms caused by A, undermining the rule of law and or the purpose of an institution, profession, or other relevant body. We're entrusting you to be honest and to be fair. B, failing to perform a function whose proper exercise is in the public interest. Well, you are obstructing that person's ability to go through their asylum claim. You're obstructing their ability to go through their asylum claim. And so you're creating these obstacles. And what that does is that you're failing to perform a function whose proper exercise is in the public's interest. And what function is that? Every person has the right, if they file asylum, to go through the process and to go through the appeals process. And when you put an obstacle in that person's path that is not a legitimate obstacle and is not in policy, that is a matter of public concern. Violating established rights of individuals. To reiterate, it is a right of a person who has filed asylum to go through the proper procedures that are in place. And when you put a landmine in their path to prevent them from even going through those procedures, so you can stop their asylum claim, so you can push them out of the asylum process, that is violating their established rights. So the application of the public interest test helps to make this makes this distinction and focuses not only on the gains but also on the harms inflicted by corruption. So the gains could be, we pushed this person that we didn't want in the international protection process, we pushed them out. And the game could also be, well, not we, but the Home Office pushed them out, or the state agents pushed them out, or the Police Service of Northern Ireland pushed them out of the international protection process, right? That could be, for example, a game by the Police Service of Northern Ireland, by NISOS Group Limited, by intelligence agencies, by the Home Office. It's a game. And sometimes people are jockeying for a promotion or a role, and if they're able to engage in this and to push someone out of the international protection process, through covert measures, they're given promotion. So that is a game. And it's also focused on the harm inflicted by corruption. So what is the harm here? The harm is that the person no longer has their asylum support. The person perhaps is not going through the international protection process. You can see there's multiple harms here. And I want to reiterate that this is often done to people who are in the asylum process and are in these vulnerable positions. And so there you have it, ladies and gentlemen. Tell me what you think. Sorry that I had to split this video up into 2 sections. Hopefully we got through a lot today. There's a lot that's going on, so I didn't prepare this video the way I really wanted to. I didn't talk about it the way in which I really wanted to. But hopefully I brought this information to you, and then I'll link what I'll do is I'll link this article in the description box below, and you can review it for yourself, and you can tell me what you think about it, give me your thoughts on it. And the question is, do you think that when police plant evidence or create a crime for a person to commit, that is entrapment? Is that corruption? Should there be more laws around this kind of behavior? And should NISOS Group Limited or Police Service of Northern Ireland, Ryan LaSalle, or any other intelligence agency working through their proxies or vigilantes, sometimes vigilantes engage in this, should there be legislation in place that really, put some guardrails on the way in which power is used to entrap people, is the question. And there you have it, ladies and gentlemen. We'll talk to you next time. Bye-bye.